This is the time for oral argument in case number 1CA CV19-0057. Is it Menghini?
Menghini.
Menghini versus Menghini. Counsel, these proceedings are being recorded, so we ask you to please identify yourself and your client at the beginning of the argument, and each side will have 20 minutes. Counsel, you may proceed.
Good morning. May it please the court, I am Laura Brosh and I represent the appellate, Peter Menghini. I would also like to reserve 2 minutes of my time for a rebuttal at the end. Now, there are several errors made by the trial court in this case in relation to several properties. And unless this court would like to direct me elsewhere, I'm going to start with Corner MCR LLC. Now, the main issue in this case regarding Corner MCR is that Corner MCR is a property interest. Wife is arguing that Corner MCR is her sole and separate property, and that in order to view her membership interest as community property, this court would have to find that her sole and separate land was transmuted into community property. Husband, however, takes the position that the membership interest is distinguishable from the land.
But that's contrary to Hefner versus Hefner that was issued by this court just a couple of months ago, isn't it?
Your Honor, I couldn't say, I'm sorry, I don't have that case in front of me.
Well, I'll take you down memory lane.
Yes, thank you.
In Hefner versus Hefner, there was certain property had been gifted to husband and then he took that property and created a business, and he designated the business as his sole property. And we said, yeah, it doesn't change the nature of the property just because you slap a new title on it. Isn't that exactly what we have here?
Your Honor, I don't believe that that's exactly what we have here. In this case, I believe it was the intent of the parties for this to be community property. It wasn't titled as sole and separate property.
If they intended it to be community property, they could have listed it that way, couldn't they, when they created the business?
They could, Your Honor. But I would argue that the membership interest itself was acquired during the marriage, therefore presumed to be community property.
Which is different than what we said in Hefner.
Yes, Your Honor. I understand that, but I still believe that...
Explain this to me, okay?
Yeah.
She inherited the property from her grandma.
Correct.
She owns a portion of this property with her siblings.
Yeah.
The purpose of creating the LLC was so that they could lease the entirety of the property to a third party.
Correct.
Where did the community gain an interest?
I believe that the community gained an interest when the land, because we're not arguing that husband has an interest in the land. We're arguing that he has a membership interest in the LLC. And the LLC is not just the land. It also includes the value of the lease.
But the lease and the land run together. If you take the land out of the LLC, what do you have left?
Well, I wouldn't necessarily say that they're indistinguishable. The LLC did receive a letter of intent to purchase the lease alone without the land. I believe that they asked for an easement on the land, but they were purchasing the lease solely. So I believe this letter of intent kind of shows that the lease itself can be distinguished from the land.
It can't be separated from the land.
Right. I believe that having an easement on it would allow them to purchase the lease, but I think that shows that they're two separate assets, the lease and the land.
And I guess I'm just disagreeing with you. How you talk about an easement runs with the property, does it not?
It does, yes.
So is there any way to separate distinctly the leasehold and the land ownership?
And I believe that there is. The land can be separately valued. The lease can also be separately valued, which we have done, and several of the experts that testified at trial did do. They valued the membership interest in the LLC by removing the value of the land and valuing the lease solely. So I believe that it can be separately valued.
Were you separately arguing that that wife's contributed labor was created a community asset? Is that?
Yes, Your Honor. Both wife and husband contributed labor during the community. Now, wife does argue that husband didn't do much, but she does admit that he did engage in some of the creation of the lease.
But
And
did her share of the property, did they get a proportionate increase in their share over what her siblings had? That she still just has a 1/4 interest in the property, is that right?
it's a 1/3 interest.
1/3? But she didn't get a greater interest by virtue of having contributed some effort to the creation of this?
No, she did not. I believe that the way that the LLC was set up was that each sibling would be an equal 1/3 member.
Then why isn't that just kind of managing, if there's some separate property and I'm just taking some actions to lease out separate property that I own, why are my actions somehow create an interest in a spouse in just going and signing up a tenant for property that I own separately?
In this instance, in your hypothetical, then yes, we would be creating a new business during the marriage, and therefore it would be presumed to be community property.
Which, going back, is contrary to
Right.
what we said in Hefner versus Hefner.
Yes. Given the court's ruling in Hefner, I would also point out that husband does have a community lien on corner MCR, and the trial court failed to calculate any sort of community lien for father in this case.
Didn't father obtain some benefit from the lease payments? Didn't those go into the community?
Yes, actually, wife did testify that the community, or that the lease payments were deposited into community accounts.
Well, what's the value of the lien other than based on the contributions in setting up the entity, which I assume you could just place an hourly, you could figure out how many hours were spent on that. Wouldn't you just have a community lien for the value of the services rendered?
I would say that would be one portion of the community lien, but then you also have to look at the increase in value, and the increase in value would be the value of the lien. You have a business entity. I believe that you have to do a business valuation, and so the 30-year lease would have to be valued.
And you're saying that's separate from the value of the separate property, the land itself?
Right. So we're saying that he has a community lien in the LLC, in her membership interest. So that would be a community lien where we have to value the business and determine his or the community's interest and lien in that membership interest. And the membership interest, you would have to value the lease for the whole 30 years. In this case, and even as you said, you could calculate the hours spent, the amount of time, and put some value on that. The trial court didn't even do that. They didn't calculate how many hours father spent. They didn't calculate the amount of time that was spent, give them a reasonable rate. So I believe that the trial court erred in that aspect as well.
Well, how much money was attributed, did wife ultimately deposit into the community account from the lease?
I believe that it was around, I want to say it was around $150,000
Total.
total.
And so he had the benefit of receiving as a community $75,000.
I believe that, so he did have the benefit of receiving that. However, I don't think that that amount would sufficiently offset any.
Well, what would be a broker fee what would be the broker fee to secure such a lease? Because that's what you're arguing, is he was a broker fee. He negotiated the terms of a lease. That's a broker fee. How much would it be?
I don't have that information in front of me.
It wouldn't be perpetual, though, would it?
Well, I believe that the lease itself, all of the work done to create and form the lease was done during the marriage. So I think that the whole entirety of the value of the lease has to be taken into account.
Well, why would we give him more? Why would any court award him the value of the entire lease when it's not his property, and would only look at what a broker fee? I mean, that's at most of what he would be entitled to as a broker. In similar vein, would be a broker fee.
Well, so husband contributed his labor, but wife also contributed her labor during the process as well.
So it wouldn't be an entire broker fee. It would just be a portion of a broker fee. So give me a ballpark. What would a broker fee be for such a lease as this?
Your Honor, I can't say. I could look it up later and provide supplemental
No,
briefing.
But assuming we take out the lease payments, you think the amount that was deposited into and the community has the lien for the entire amount based on her contributions, her labor, and his labor. But is there some argument that it's greater than the amount that was placed into the account if you subtract out the lease payments?
If you subtract out the lease payments, I believe that, are you talking about the lease payments that have been already made to the community or the future lease payments?
The future lease payments.
I believe that if we took out the future lease payments, then yes, it would equal out. Although I do still believe that the trial court erred in not actually providing that calculation or providing any kind of sums indicating how much.
But you agree that it's harmless if there's no
Yeah.
discussion by the court. There was adequate compensation.
Yes, Your Honor. But I believe that not calculating the future lease payments is error, as we have, fundamentally, we do have a business. And to do a business valuation as of the date of service would include future income streams, future revenue. And many of the experts in this case did value the future income and future revenue. I don't think that it's appropriate to say that husband only has an interest in something that was created entirely during the marriage, only for the few years that it was in place.
Let's just say this is just a house and it's just being rented.
Yes.
They secure a tenant during the course of the marriage. Are you saying the community has an interest in, after the divorce, that husband still has an interest when that tenant moves out and a new tenant moves in?
I think it would depend on whether or not that home is held by an LLC. Is the home in a corporation? Has a business been made during the marriage? I think that in this case, we do have a separate membership interest in an LLC that holds the land. That's separate than just an individual or sole and separate property. In Drawhouse v. Wren's, community lien includes any appreciation or increase in value. And I think in this case, if you're looking at the membership interest in the LLC, the increase in value would be the lease itself. The lease added value to this land, and by not including all of the lease payments throughout the entire 30-year term, that would not be a proper calculation of a community lien in this instance. Now, there are several other properties. We have.
Could I just ask you about that? Just,
Yeah,
sorry
absolutely.
to interrupt. But if you were placing a value on the land the day before the lease was entered into, wouldn't the land have value anticipating that it could be used in that manner? Isn't that part of the value of the land? Why does having the lease now change this particular tenant change the value of the land? Going back to my question about a house, it's been appraised at this amount. This is the value of the land. We have a tenant. But,
Right.
The day before we had the tenant, the land was presumably appraised at this price. What does it change the day after we have a tenant?
I don't think it changes the value of the property at all. In this case, I think that the value of the property is not really the issue. The value of the property is the separate asset that the LLC holds, which is the lease. So we would have to value that separately. We're not including the lease as value to the property, but as an asset held by the LLC.
But again, if you take the property out of the LLC, the lease cannot survive without it, can it?
No, not without an easement being granted.
Okay, let's go on to the Walton property if
Yes.
we could.
So the Walton property, the Walton and the Betty Elise properties are both were both held to be community properties by the court. And in calculating the community or the equalization payment in Betty Elise, the court awarded the home to wife with an equalization payment of 1/2 of the equity to husband. For Walton, the trial court awarded the property to husband with an equalization payment of wife of 1/2 the entire value of the home. Pursuant to ARS 25318, while it doesn't have to be divided in kind, it does have to be equitable. And by using two different standards, using the division of equity in one case and the division of the entire value of the home in another, is not equitable. We believe that the appropriate calculation should have been 1/2 of the equity of the Walton home. Now, there are also several properties that this court found to be wife stolen separate properties where we believe that the court improperly calculated the community lien. The first one is the Rudy property. Now, in this one, the trial court erred by not calculating any appreciation value of the home or of any of husband's labor in managing the property. The parties agreed that husband was responsible for managing the property, and husband's expert included a value of husband's management services in his community lien analysis.
Management services increase the value of the property?
I believe that it's labor that should go towards value of the lease. It increased the rental income. It helped with.
But doesn't that circle back to what we were arguing before? Is he did receive the benefit of having that money deposited into community accounts, right?
For which property? I'm sorry.
The properties we're just talking about.
For the Rudy property? So the Rudy property, all of the rents that were deposited pretty much equaled out to the mortgage payments that they were making. Except for, I believe at the very beginning, there might have been some where they did not have a renter at that time. Okay. But what the trial court failed to calculate mainly is the appreciation in value of this property. Husband's expert testified that this property increased by approximately $100,000, and in calculating the community lien.
What part of the community was paying for that if the rents covered the mortgage?
So they were paying for maintenance. The property is in Colorado. There were several times that they had to pay to go out and maintain the property. There were also several payments that they made at the beginning of the marriage prior to the rental of the home.
You're talking about a disagreement, though, as to whether the property actually increased in value or not.
Yes, Your Honor.
And isn't that a credibility call that we would defer to if the Superior Court accepted the view of one expert over another?
Your Honor, it is something that this court can defer to the trial court. However, if there's no evidence to support this conclusion, then there has to be found an abuse of discretion. And I think in this case, the fact that no amount for appreciation was included is not supported by the evidence in this case.
I thought is this not the one where the court took the middle figure of the range submitted by the experts?
No. In this case, husband's expert testified that the value had increased by approximately $100,000, and wife's expert testified that there was no increase in value and that they believed it depreciated. But the trial court didn't indicate that it was adopting one expert opinion over another. It just said this.
Isn't it implicit in the court's ruling? Sorry.
In the court's ruling on this property in particular, it did not say any type of calculation. It just says there is a community lien totaling $35,250. It didn't say how it was calculating that amount. It didn't say here's the community contributions, here's the price of the or the
community
value
contributions don't have anything to do with what the value of. Somebody's just deciding what's the value of the house now and how much it's appreciated.
Right.
We don't care what contributions for that purpose.
Right.
And the court accepted the lower figure, right?
of the community contributions or the value?
No, the value of the property.
The court didn't make any value of the property. They didn't value the property at all. They only found there was a community lien totaling $35,250. It didn't say one way or another if it was adopting husband's expert, wife's expert, what it was basing that figure on.
Did you ask for findings of facts and conclusions of the law below?
Your Honor, I believe that we did. I believe that findings of facts and conclusions of law were submitted to the trial court.
When the ruling came out, was there a request to clarify?
No, there was not, Your Honor. I'm sorry, I have to.
Counsel, you have less than a minute
Oh,
remaining.
thank you. I would like to reserve the rest of my time for rebuttal.
All right, you may do so. Mr. Winter.
Thank you, Your Honor. Good morning, Your Honors. For the record, may it please the court, my name is Brian Winter, and I represent the petitioner, Christine Schemer, formerly known as Christine Menghini. I will also be reserving a few minutes, 2 minutes out a lot of time for rebuttal, Your Honors. I would like to begin by saying that this matter was litigated for over 2 years, which culminated in a full-day trial. There was a trial on the merits. There were 4 expert witnesses, and both parties testified. There were over 240 exhibits submitted to the court. This record, in this case, is very voluminous and very detailed. There has been 2 appeals, one of this decree, one post-decree, as well as a special action that was filed by Mr. Menghini. So for anything that I do not reach, I would say that the record is sufficient for this court to make a ruling. There's also been quite a number of post-judgment filings, which I think goes to the reasonableness and goes to attorney's fees to show that I believe this case has been over-litigated and there were many unreasonable positions taken by Mr. Menghini at trial.
Could you address the division of the Walton property?
Yes. The Walton property was divided by the court in the sense that the judge determined there was sufficient evidence put in. There were experts regarding value, community liens, and this was a community property. The judge had attributed a value and given my client half of that value. Our position is that community division of community division of property is not always equal; it's equitable.
Okay, well, let's talk about that and talk about reasonableness. In factoring all of the different awards here, I come up with roughly over $600,000 that was awarded to your client and only $430,000 that was awarded to husband. How is that anywhere close to being equitable?
Well, a lot of what was awarded in this, Your Honor, was community liens on properties. So it's not always equal when you're dealing with community liens. And for example...
Well, you're not answering my question.
I'm sorry.
The difference, it's still supposed to be equitable, and I'm asking you how a difference of that magnitude is ever equitable unless it's explained.
I don't believe that the trial court did make an explanation of that, Your Honor.
Okay, and if we do just rough math and notice that if she'd have used the correct calculation for the Walton property, doesn't that make it almost equitable in this case?
Yes, Your Honor, but I would also argue that the judge did not do an equal division of the Payson property either.
To this magnitude?
Yes, Your Honor, I believe so. In that case, they took the purchase price and the judge used that to determine the value of the property rather than the appreciated value or the value at the time of the dissolution. So that was not an equal division either. I will admit that the judge did not explain the reasoning in this case of why to do those 2 properties different, but just because the Betty Elise and the Walton property were not treated identically the same, I do not believe makes it inequitable because this was done with other properties as well.
When would it ever be logical, equitable, logical to not factor in the mortgage on a property? When we have, this is $1 million property, but there's a $900,000 mortgage on the property. To suggest that the parties are getting $500,000 or that you're going to divide $1 million by 2 to determine the party's interest, wouldn't you need some explanation in that circumstance?
I think it certainly would have been helpful if the judge had explained that, Your Honor.
But doesn't it just look like the court would have overlooked it and just forgot about the mortgage on the property?
Except for the fact that the mortgage was also stated in the decree, Your Honor, I would agree with that statement. It was stated in the decree that there was a mortgage on the property, but for reasons I can't explain to the court, and there was no request by either party for reconsideration or articulation or anything else. There were no findings of fact, by the way, submitted in this case.
I would agree if the amounts here had been $1 million on the Walton property with a $900,000 mortgage, that would be improper to attribute $500,000 to each, to husband and wife. And if one party's keeping the property, it would be unfair to not account for the mortgage.
Yes, it certainly can be, Your Honor.
So at what point do we say that this is a small enough amount that we'll just ignore it?
I don't know if I would say if it's a small enough amount or not small enough amount, Your Honor. I think it comes to whatever decision the trial court wished to reach on an overall basis and take everything into consideration. I think if you take the entire decision and decree into consideration, you look how different properties were treated, which experts were agreed to, which clients were maybe more credible, I think you come to an overall result, which is what I think was done in this case.
And if we do that, it shows that your client got roughly $150,000 more than husband. How is that? I'm coming back to how is that equitable?
I suppose if you're going to do a community equalization, it wouldn't be equitable, Your Honor.
Well, I'm not saying it has to be equal, but
Right.
at one point in time, when you're looking at disparity in awards, do you say this is not equitable?
I think it's done on a case-by-case basis, Your Honor, and I cannot explain what the trial court did. It would appear on its face to be inequitable, but because the reasoning was not in the decree, I cannot explain why
But
the
if it
court.
appears on its face to be inequitable, doesn't that kind of call out for an explanation from the Superior Court? If the presumption is it's going to be an equitable division, and if we see something, doesn't it look like it's just an oversight by the court that needs to be corrected?
It could be, Your Honor, but I don't necessarily think that rises to an abuse of discretion. I do think the trial court does have discretion in the equitable division of assets.
But you agree if it's $1 million off and you've ignored the mortgage on a $1 million property, that's an abuse of discretion?
I certainly think so, yes, Your Honor.
Isn't it more likely that the judge simply forgot to subtract out the mortgage before dividing the equity? Doesn't that sound like the most reasonable explanation?
It sounds like a very reasonable explanation.
Okay. Can we go on and talk about the $4,779 in health insurance coverage that the court ordered husband to reimburse wife's parents for?
Yes, Your Honor.
Let's address that.
During the entire action, and during the marriage actually, Ms. Schemer's parents paid for the party's health insurance. When the divorce was filed, they asked for Mr. Menghini to pay his share, which was $177 per month. Mr. Menghini
Hold on. Where in the record is there anything that would indicate there was a contractual relationship between husband and wife's parent?
No, Your Honor.
And anything that suggests that husband agreed to something?
He made the first payment, Your Honor, and by doing that, he implicitly agreed or acknowledged that he owed the debt. And I will say that no objection is on the record to any of the health insurance payments. It was not raised at the trial court level, Your Honor, and I don't believe it's appropriate for Mr. Menghini to raise it on appeal if it wasn't brought up at the trial court level.
No objection, though, at what point is he supposed to object?
He could have objected on the record. He could have elicited testimony. It wasn't even objected to in his pretrial statement.
And that was part of the pretrial statement from wife saying husband is required to repay this to her parents.
And I believe it was also, I don't believe it was addressed, I can't say as I sit here, in husband's pretrial statement, Your Honor.
So is this a community obligation that was because certainly during the marriage when the parents were making these payments, that's a gift.
Yes.
So after the petition is filed, is there a community obligation?
I believe at that point it's not a community obligation. It was an individual obligation.
And what statutory authority does the court have to order husband to pay an individual debt to a non-party to the action?
I don't know of any statutory authority, Your Honor.
Would the court even have subject matter jurisdiction over that issue?
I don't know the answer to that, Your Honor. I know that it was addressed at trial and it was not objected to. There was testimony by my client regarding the payment of the insurance and the repeated request and promise to pay, but no payment being made.
Couldn't the parent simply have canceled his insurance? when
They
he
could
couldn't
have, but
pay?
my understanding, Your Honor, is they didn't want their former son-in-law, the father of their grandchildren, to go without health insurance.
So wasn't it a gift?
They didn't see it as a gift.
But he missed payments. If he made one payment and then missed it, I mean, at some point, don't they have to come in and have some sort of agreement for there to be an obligation on the part of husband? Why isn't it still a gift? They didn't want their grandchildren's father to not have insurance. That sounds like a gift.
Well, I don't think it was intended as a gift because they kept making a demand for payment, and he did make one payment. I think if it was a
Well,
gift,
so they can file a lawsuit and get the money.
they certainly can, Your Honor. We just attempted to deal with or address it in the family court matter rather than having to go through a separate civil matter, which would cost probably far more than the amount that's requested. And if I may address, Your Honor, going to corner MCR, as that is the biggest part of this case.
Well, before we get there, and I'm not saying I don't want you to talk about that, but the family LLC, the trust issue,
Yes, Your Honor.
the trial court made no allocation in the decree on how to put the evidence, to put the communal interest in trust for the children, did she?
No, Your Honor. I believe that matter was outside the purview of the family court.
Why
That was-
not? It was community interest until the decree was issued.
Correct, but once once the divorce was finalized, it was all contractual through an LLC, which had language in the operating agreement which specifically stated upon a divorce, the married couple, in this case the Menghini's interest in the various LLCs, because there's more than one, I think there were 4 or 5, ceased to exist and it passes to the children. And the trustees of the trust had set up a fund for the money for the children to go into, which is where it's going right
The
now.
trustees, or the trustors?
Both. The trustors are the trustees right now.
And who are they?
That is my client's parents.
So there already is, I was reading it, so you're saying it's not the husband and wife's obligation to create a trust, you're saying the trust already exists?
I believe it was already drafted and prepared by my client's
Your client,
my client's parents.
prior to the dissolution proceedings being formulated or after?
I believe the trust was drafted during, but the official payment
During,
that was drafted during the proceedings. However, Mr. Menghini received payments from the LLC as of the date of divorce. So it was after the date of divorce that it went to the children.
Did the operating agreement set forth who would be the trustee, how the trust would be set up, how the transfer would occur, any of that information?
No, it did not, Your Honor.
So basically, the operating agreement does not establish who is the trustee, how the trust is to be set up, who is to administer it, how the property or the interest in the LLCs is to get into the trust. None of that is set out.
I do not believe so. When I read the operating agreements, which is some time ago, Your Honor, the only provision in there had to do with how the married couple or any of their children, it was an omnibus provision. If any of the children, they all had separate trusts or LLCs in that trust, or I'm sorry, in those operating agreements. Once that terminated, those funds were to pass immediately to the children, but it did not have a mechanism for that. So what the trustor or the settlor and the trustee did, they had set up their own trust, and I know that both parties, Mr. Menghini and my client's parents, have been dealing with probate attorneys also on that issue.
So there is a separate proceeding that's already underway?
Nothing has been filed, just letters back and forth from probate lawyers.
I'm just curious at how there clearly is a community interest in these LLCs until the time the dissolution decree is issued. But why the trial court would simply ignore that? I mean, it may be as simple as ordering one side or the other to set up a trust to conform with the operating agreement. But I don't know if she can ignore it.
I still think, Your Honor, and I respectfully state that I do believe that that is a matter outside of the family court. It is, if they want to deal with the issue, it goes to the probate court if somebody wants to institute litigation on how to deal with the trust in the LLC, or a civil matter, the trust in the LLC's interests. The clients, the parties here no longer have an interest.
Well, they only no longer have an interest once the decree is issued.
Correct.
And under the statute, the court has authority to dispose of community interests.
Yes, Your Honor, the court does.
So shouldn't she have directed, shouldn't Judge Record have directed how it was supposed to make sure that it was in compliance with the operating agreement rather than just simply ignoring it?
I think it would have been much more helpful if there was some guidance from the Superior Court. But I think, I'm using supposition for the judge, Your Honor, but I think the judge's position was this is being dealt with outside of these proceedings. And our position at trial was that this was a separate business interest outside of the parties, and that was being dealt with through in a different forum, wherever that forum may be.
And I interrupted you. You wanted
That's
to
fine,
talk
Your
about-
Honor. I'm just going to briefly state about Corner LLC is that I find it very interesting that Mr. Menghini is arguing a community interest or a lien on the LLC itself when neither of his experts at trial presented any evidence on the sole and separate interest versus the community interest. They solely valued my client's interest in a lease in perpetuity for assuming the lease would go the entire term. We had our expert, Mr. Donald Bays, prepare two analyses. One was my client's sole and separate interest versus a community interest, and Mr. Bays opined, I believe correctly, that under Dreyhus, that the appreciation of the property or the value of it is only during the marriage, which is what it states in Dreyhus. It doesn't state in perpetuity. So the first analysis was the value as of the date of service, or at dissolution when we finished this case. And it was determined that the amount that the community was paid by my client, because she had taken all of her community funds and put it into the community accounts, exceeded what he calculated to be the community lien. And he came to a value of 0.
Well, Dreyhus is not the only way you can establish a community lien in a circumstance like this.
Correct, but we were directed to do so by the trial court in the decree, or sorry, the minute entry for the motion for partial summary judgment.
But assuming you can do other things, and we're looking at other things that can be done, it isn't the claim that he brokered this lease. So aren't we really just talking about a brokerage fee? He would be entitled to something of a brokerage fee? Or the value of a brokerage fee?
Even if you were entitled to the value of a brokerage fee, the community had already benefited, and he would have received the amount of money we believe in excess of any reasonable brokerage fee for what my client took from the lease payments and put into the community already. So that's why Mr. Bays found that the community lien was 0, and it would be implicit in the judge's ruling, because the judge is in the best position to determine the experts, the witnesses, and everything else, that the judge agreed with Mr. Bays' reasoning by not awarding any interest to him from the community, and I believe it was even mentioned in the decree that the community had benefited. May I reserve the rest of my time, Your Honor?
Certainly.
For rebuttal. One last point, I'm sorry.
All right.
With regard to attorney's fees, we believe that there has been, the standard used by the judge was incorrect. Under the statute, it's reasonable positions, and in the decree itself, Judge Record stated that neither party was exceedingly unreasonable, which is not the proper standard, which is why we did the cross appeal. We believe that Mr. Menghini was unreasonable in asking for spousal maintenance, which he did not appeal, claiming a community asset of corner MCR and many other things, not going to mediation, et cetera. Thank you.
But it's not just the reasonableness of the of the parties' positions, but the financial resources of the parties as well.
That is correct, Your Honor. And the judge found that he was not entitled to spousal maintenance because he had financial resources on his own. So it could certainly be reasoned he had the financial resources to pay his own legal fees. My client had to take out a line of credit to pay her fees.
All right.
Thank you.
Counsel, your time has expired.
So addressing the attorney's fees briefly, while the standard is whether the positions were unreasonable, and the trial court did say whether exceedingly unreasonable or stated that neither position was exceedingly unreasonable, they did state that differences in opinion or positions do not necessarily constitute unreasonableness. And I think that's all we have in this case is differences in opinion. So I believe that the court made an accurate determination as to attorney's fees in this case.
Can I ask you, counsel, on the trust to be set up for the children? What's your client's position on what the court should have said?
We believe that the court should have addressed this issue and should have ordered the parties to create a trust where mother and father were both trustees of the account and they both had equal say in how the trust was distributed.
And there's a basis for requiring that both parties be the trustee?
I don't think that there's a basis for requiring that, but that would be our position if the trial court were to order that. We do think it's error that the trial court did not address it at all when it was an issue raised.
Would it be error if the court were to just say, I'm going to leave this for the probate court to set up a trust, or someone to file in the probate court and include the original trustors in that proceeding?
No, I don't think it would be error for them to do that.
Well, is there even there is not even a probate action filed?
There's not. No, that is correct.
All right. All right, the matter is deemed submitted. We'll issue a decision in due course. Court's at recess.